Welcome back, friends. On today's episode, Andy sits down with Kara Chrobak, a Colorado State divorce attorney, to discuss all things prenup, post-nup, and common law marriage. Stay tuned, you might learn something new.
Okay, it's a subject some of us don't want to talk about, but we should. Even if you're not getting a divorce, you have a happy marriage, but maybe you have friends that are going through it. We do not have a crystal ball. As much as people ask me in my business, what do you think's going to happen in the future? Don't know. I can just give the best advice that I can and always be thinking about the future, what can maybe happen. So welcome.
Thank you.
Thank you for being here.
Thank you for having me.
Much appreciated. And give everyone a little bit of background about you, where you grew up, where you went to school.
Sure. I'm a Colorado native. I grew up in Lakewood, Colorado. It's a suburb west of Denver. I went to undergrad at the University of Denver, and I went to law school at the University of Colorado.
I love it. Colorado native.
Colorado native through and through.
Through and through. And
Yeah.
You come up here, you get to come up to Vail once in a while.
I'm so envious of all of you that get to live up here. It's so beautiful.
Well, it is. I try not to get down to Denver too often. I hate to say that.
Fair.
But I like my bubble up here. So tell us a little bit about how you got into the family law and divorce attorney in particular.
Sure. So I started my career practicing big law for an international law firm in Denver. And in that capacity, I was doing civil litigation, which means fighting over contracts and representing insurance companies. I loved about that job the complexity of what I was doing, the sophistication of the work, the critical thinking that was kind of associated with it. But what I really felt missing was the tie to the community and the connection to individual people and feeling like I was actually helping people. So I made the pivot to start practicing family law at another Denver-based law firm about 7 years ago, and started doing that work at a very sophisticated high level, representing high net worth and ultra high net worth clients, and really working with individuals who have very complex divorce-related issues. And so I felt it satisfied the desire to really keep doing the sophisticated, complex types of legal work, but also in a way that I really felt was helping people and connecting to the community.
Awesome.
Yeah.
I love that.
Yeah.
Yeah. So we have really two different subjects here that I would love to have people learn more about.
Sure.
And for you to share. Let's start with the common law marriage aspect, because there are a lot of people at all different age levels that cohabitate together, and all of a sudden the years go by, never got married officially. So talk a little bit about what the common law marriage laws look like here in Colorado first.
Sure. So typically speaking, to be a married couple, you need to go to the clerk and recorder's office and get a marriage license. And that's the legal document that makes you officially legally married. In Colorado, we still have a longstanding law that allows individuals to also get common law married. And Colorado is one of a handful of states that still has common law marriage. It was something kind of from the olden days, a way to make it a little bit easier so people didn't have to ride horses down to the city to get married. But it has kind of stayed in effect, and it remains in effect today in Colorado. And so what that means is that you can either go down to the courthouse to get married with the legal document, or you can just intend to be married in Colorado and hold yourselves out as a married couple. And that, in some realms, and depending on the circumstances, can create a legal marriage in Colorado.
That's an interesting fact. I didn't know that. But what if someone didn't have the intention, but years go by, someone's been together, I thought I've heard 7 years. Is there a particular year that even if you didn't have an intention to go down to the court, but you are together and cohabitating under the same roof, is there a certain, years or anything that specifies that, okay, I didn't intend, but we've been together for X amount of years.
So it's funny you say that, because before I went to law school, I also thought that it was a required amount of years that you needed to be together to create a common law marriage. For some reason, I had 7 in my
Yeah,
mind.
same
I don't
thing.
know where that came from.
I don't either.
But it's not true, actually. So in Colorado, you don't have to be married, or you don't have to hold yourselves out as married for any duration of time. It can be as short as 1 year, 6 months. It can be as long as 30 years. You can be in a relationship and never hold yourselves out as a married couple. And so then you would never create a marriage, a legal marriage. So the duration's actually not relevant to the consideration.
Interesting.
So, and in your situation where you were saying, for example, what if you're just together and you're not intending to hold yourself, to be married, you would not be creating a common law marriage in that situation. The court, when evaluating a common law marriage, it's like very fact specific. Like they look at a bunch of different things to try to determine whether or not the parties intended to be married. And so what they'll look to, it depends on the situation. So not one element is always going to be like the end all be all, but they'll look to things like, are you guys filing joint tax returns? Are you guys jointly on health insurance? Are you both jointly on deed to your house? Do you, celebrate your anniversary? Do you wear a ring? Do you post on Facebook about how much you love your husband? They're looking for really indicia of an intent to be married, kind of factoring all of it together. So if you just file joint tax returns, that might not be sufficient to create a common law marriage.
Okay, that's great. That is new to me because so much, seriously, I have several friends that I know that have been together for years, and they brought up the 7 years, and so good for either party to know that, to not think that because you've been together for X amount of years, that all of a sudden qualifies you as a common law marriage.
It's not. It actually, duration, again, has nothing to do with
It's the intent.
It's the intent. But what can be really tricky about common law marriage, and specifically in the world in which I practice law, which is dealing with a lot of individuals who have high net worth and ultra high net worth, is there can be some big problems with it. For example, if you're not intending to be married, but you have some indicia of a marriage, and you're the moneyed individual, and you have your new, significant other who's like, a 20-year-old hunk, right? And you're living together, right? And you break up, and your hunk is mad at you because they don't want to be kicked out to the curb because you were the one providing for them. The hunk might be incentivized to try to claim a common law marriage, even if one didn't exist. And in doing so, sometimes the cost of litigating it can be really expensive. So you might be in a situation where it makes more sense to just pay them to settle the common law marriage claim rather than litigating it. So you can really create some potential liability just by being in a serious relationship with an individual because of the common law marriage rules in Colorado. One of the things we do, though, is we do recommend people have what's called a cohabitation agreement. And what that is if you're going to be living with an individual, if you don't intend to get married and you're not married and you don't want to have this risk of a common law marriage coming at you, we would do a cohabitation agreement. And what that provides for, they can be, as sophisticated or as simple as you want them to be, but it's basically just a legal document that both parties sign that provides, we are not married, we do not intend to get married. In the event we get married, we will do a prenuptial agreement, like there's no common law marriage here, so that then in the event you guys were to break up, we would at least be able to look back to that document and say, this undercuts any claim to common law marriage.
Wow. Okay. Did not know that exists either. And that may be a simple solution for a lot of people to think about.
Especially in your world when you're dealing with people who are buying property together. It's certainly something to mention to them when you're kind of talking about, joint tenancy and how are we going to do this. And, just so you guys know, there's common law marriage here. So be thinking about that too as you're entering into.
Right. Because that does happen. I mean, we're in an area that we have primary homes, second homes, and that is something to think about because I have had some situations where they're not married. And then, I do need to ask how this property is going to be held in title. And if it is one person and their intention is for both of them to live there, that may be something just to have as informational purposes.
Absolutely.
Yeah.
Yeah, especially when you're involved in those kind of transactions, because that's when you typically see that conversation the most,
Yeah.
when people are moving in together.
Okay. Well, great to know that
Yeah.
there is that agreement out there.
Yes.
Yeah.
And the other thing that's tricky about common law marriage is for individuals who are high net worth, they oftentimes would anticipate entering into a prenuptial agreement or a marital agreement before an actual legal wedding or legal ceremony. And so when you have common law marriage, you kind of have this issue potentially of a marriage that happens without ever doing the prenup that you were contemplating or planning on doing. And so it's just very good to know that there's a common law marriage issue out there. And if you're an individual who, is high net worth, to make sure that you're consulting with your advisors, your team about making sure you protect yourself so that if you're going to get married, get a prenup too.
Yeah. Well, okay. So now let's jump to the prenup. Okay.
Sure.
And we're going to move over from common law to marriages. So talk a little bit about prenups, of what type of prenups or how that actually works.
Sure. So prenups we do in Colorado a lot. They're provided for by the law. We can also do what we call marital agreements or post-nuptial agreements after you're married. So it's not imperative that you guys do it before your wedding day. If you can't get it all done and you need to do it later, you can always do it after your wedding day at any point in time during your marriage, as long as you're not about to get divorced, obviously. If you do try to do that, you're going to have some issues with the enforceability. But so Colorado recognizes prenups. I tell my friends, anytime, I don't think you need to be high net worth to warrant the need for a prenup. I tell any of my friends who own businesses, my gosh, please get a prenup, because for no other reason than just avoiding the cost and headache of getting your business valued. If you guys were to split up, it's so much more streamlined if you have a clear provision for how you're going to deal with the business interests that you own. The same is true, obviously, for any individual who's a beneficial interest in trust, who anticipates significant inheritance during the course of your marriage. Second marriages, prenups make a lot of sense for second marriages because of how the estate would be handled in the event of your death, and also in the event of a divorce, to make sure that, especially if you have children from your first relationship, that your property goes to the child and not into the marital estate. So, there's a lot of different situations where prenups make a lot of sense that are not always just for like the ultra high, rich celebrity people.
No, I agree. And again, we're here where people come and buy their second home, third home, fourth home. And it is something to think about, because we see a lot of longtime married people, but we also have a lot of second plus marriages that happen here. And then you start adding all those different layers of properties that should be considered. And a lot of them are in trusts, which we'll talk about here in a little bit. But how do you avoid the pitfalls of some of these?
I had a client a few years ago who had a bunch of real estate, owned a ton of real estate, had inherited it prior to his marriage, and during relatively short-term marriage, not very long, less than 10 years. And during the course of that marriage, the real estate appreciated like crazy. Okay. And a lot of the real estate had some complex lending and complex options that had been in the works for development during the course of the marriage. It did not have a prenup. And so it made it so challenging to value the appreciation of that real estate that transpired during their marriage. Because in Colorado, obviously the assets that you bring to a marriage are going to be set aside to you as your separate property, but anything that appreciates or that you acquire during your marriage is going to be marital and subject to division. And so for this case, bringing all those real estate assets to the marriage would have been set aside to the individual as their separate property, but the appreciation and valuing that's all going to be subject to division. And so if there was a prenup, which in this situation was perfect for a prenup, the appreciation could have very easily just been all set aside to that individual, and we would never have had to spend the years of litigation trying to determine the values that constituted that marital estate. So when you were talking about cases that go on for years and years, that is probably why a case would go on for years, is trying to get, that can be a very exhaustive process and very expensive to do.
Yeah, I've even had some attorneys reach out to me in a case. I don't know if it was actually based on the divorce, but it was a case where they needed to go back in time
Yes.
to come up with what the value was of the property back a few years ago. So
Yes, and that would be for purposes of trying to figure out the appreciation. We call that a retroactive appraisal. And you're trying to get the value as of the date of the marriage, so then you can figure out the value today and figure out how much it's appreciated.
And it's actually, I have one right now that they're asking me, not in the divorce, but it's the divorce or death appreciation and what the
Yes.
value is. And that's a total different appraisal than what a fair market appraisal
Correct.
is. So it ties in, I think, with the divorce and death appraisal.
Yes.
Yeah. Okay. So good to think about. And
Yes.
I don't know if you want to give advice, but I do know of several people that have had ongoing divorces with businesses tied in, and people probably didn't have a prenup in that case. Anything that you can maybe suggest or recommend to kind of think about? For me in my business, sometimes we have some people that want to go for the kill. Okay, whether it's a buyer or seller, someone feels like they want to be the winner. And I say, if someone really is out to be the winner, there's going to be someone that's really going to be the loser. And it doesn't feel good at the end, at the closing table.
I mean, in theory, the prenup would help negate some of that. One would hope. That's the point of a prenup, is to really streamline the cost and the time of a divorce case. But, assuming there is no prenup involved, I don't know what specifically is causing the cases you referenced to go on for as long as they are. It's possible the valuation's taking a while, or they need certain information in order to complete the valuation. A lot of that can take, a year or more to just collect the information. But if the issue is just pure interpersonal conflict, I would say that I grew up playing sports. I love to win, but unfortunately, family law is one where you just don't really win. There's no winning. Everybody walks away from a divorce feeling like, or not, I guess I shouldn't say everybody, but most cases, people walk away feeling like, man, that was not great, right? And there's no real win. So we have mediators all the time say, if you both can walk away from this deal and be like, I can live with this, that means you reached a good deal.
Yeah.
So I think that, for those people who are wanting to win, I think working with them on appreciating that there is no win will help bring it to a close, probably, because the only people who win when you fight for years is honestly the divorce lawyers. So it's just not good for anybody. It's better to move on.
That's kind of the joke at the end of it, which is
know.
not so funny.
I know.
I think perhaps it's really getting the message out to people, because I think when the prenup kind of statement, people get a little nervous about it because it makes people feel uneasy. Like, why are we doing the prenup? Because that means that someone may have the intention of divorce at the end of the day. What's that messaging to people maybe so it's not a negative, it's more of a positive messaging?
Yeah. I mean, I think that there's a few things you can do if you're kind of approaching that conversation. I think for a lot of people who are individuals who a prenup would make sense to have, they're business people. And so if you view that like any other contract, it's like an insurance policy. And if you don't have an insurance policy, it's really risky. And so I think having the conversation from a much more transactional, less emotional business type of a discussion, I think I would hope both parties would appreciate that when you're talking about, I'm just looking out for X, Y, and Z, there's no emotion to this. The other thing to point out is that prenups don't always mean that everything is going to me and everything's going to you, right? So if you approach the conversation, and I actually think that it's a good idea to do this in general, of, hey, I have this business, this is my blood, sweat, and tears. I love this business, and I don't want to have this business be at issue in a divorce case. But everything else is still going to be ours to share, right? And our house will be ours, and this will be ours, our cabin will be ours. Just this business is going to be set aside to me. I think if you approach it from that perspective, you're going to get a lot more buy-in, because both parties still feel like they have a stake in the marriage and the financial well-being of the couple together, versus feeling like, well, he just wants all of everything and I don't get anything, and I don't, he thinks we're going to get divorced, and I don't love this conversation.
What about in the case of prenups, have you seen that being challenged at the end on these estates with the heirs? Do you see that being challenged on some of these prenups?
So prenups are absolutely challenged. Typically, the realm in which I work is not going to involve the heirs doing the challenge. The heirs would be doing a challenge probably in more of a trust and estate litigation, which in complete candor is like way outside the scope of anything I know about. I know enough to call somebody else to ask them questions about it, but I see prenup challenges in divorce cases all the time.
Okay.
And what that looks like is a party, for the example I was just giving of I'm taking all of my assets, you know, a spouse could try to challenge the prenup to get the prenup set aside because it's invalid. And so that does happen. It's hard to challenge prenups, but there are circumstances where a prenup challenge is warranted, and sometimes they do get set aside. Typically, the challenges are for if the agreement wasn't entered into fairly or voluntarily by both parties, or if there's not an adequate financial disclosure. So there are ways that they can be challenged, but I think it's really important for individuals who are of high net worth to recognize that they're not as ironclad as I think everybody expects them to be. They're not rock solid, and it's very important when you're dealing with a large estate to make sure that you have a prenup, and then you also have estate planning done in the background that further protects your assets, so that in the event the prenup is invalidated, you still have some protection.
Yep. So it actually can be I don't want to say a team effort, but it is. It's having the estate planning. I had it put together because with my daughter, a special needs trust and whatnot. So it's making sure everyone's clear. And then sometimes that even evolves. Have you seen where you have adjustments to the prenup because situations change?
Yep,
You see that
absolutely.
as well. So it's just keeping up to date, whether it's any type of trust, I think is the point, and any agreements, if you see fit, and doing that prior to any disagreement.
Yes. And I've had a case too. I think you bring up a really important point. So obviously having a prenup and the trust is ideal because a prenup's not always going to be rock solid, but it's also really important to know that the trust is not always going to be rock solid. So I've had clients before where they have advisors on the East Coast. We're trying to negotiate a prenup, and the advisor on the East Coast is saying, even if we can't get the prenup done, we're fine because everything is in trust. And we hear that a lot. And what's concerning to me about those type of comments is that whether or not a trust would be part of a marital estate is state by state specific. And so individual on the East Coast, whose advisors on the East Coast are saying this trust should be fine, doesn't necessarily know Colorado law. And so I always get a little bit nervous about clients relying entirely on the trust itself, because that may not always be, as perfectly tied up with a bow as they'd want it to be. And so that's why we say, it's important, even if you have a trust and it's all, off the table from the trust, make sure you get a prenup too.
Yeah. Okay. Good advice.
Yeah.
Another topic, just briefly, we want to touch upon the slats. Okay. For those of you out there that would like more information, you may want to talk to your estate attorney about them. But there are some changes that are going to be occurring at the end of 2025. What would you like to touch upon on that regarding divorces?
Yes, so slats have become very popular in recent years because of the tax-related benefits to individuals who have a significant estate. Slats are spousal lifetime access trusts, and I know enough to be dangerous, but probably not as much as an estate planning attorney would. But slats are formed for tax purposes where one individual is the grantor in a marriage, and the grantor transfers to this spousal trust assets, and they are tax protected, and the assets are for the benefit of the spouse. And so the trust is set up for the benefit of the spouse and the grantor, who's, let's say for our example, husband and wife. They're great and wonderful, except in this situation of a divorce, because a lot of times slats are drafted in a way that upon divorce or the completion of a divorce case, the wife is kicked out or the spouse is kicked out of the trust. And so what would then happen, and the trust itself is depending on how it's drafted, could constitute not property, would be not property, meaning that it's out of the marital estate as well. So you could have a situation where parties have, $20 million net worth or $50 million net worth and put the $50 million in a slat. Hypothetically, the slat goes off the table in a divorce and the two parties are left fighting over 2 cars and a bank account, where you have this massive estate that nobody's able to even access, and it's now going to the benefit of the children. So I think people who are contemplating doing slats, I think there's still always kind of that doomsday preparer side of me who says, make sure you're really talking about the repercussions of slats on a divorce case. Make sure it's drafted in a way that you understand and are comfortable with. And if you're going to be doing a slat, I know a lot of estate planners say slats are not meant to be lived off of. And so you need to have enough of an estate that's within, the other parts of what you're living off of, so that you're not relying on the slat to support yourself in the event of a divorce, because there's complexities with the beneficiaries and the fiduciary relationship that you owe them as well. So I would just say in general, if you're contemplating a slat, make sure that your estate planning attorney is savvy about how it would work in a divorce case and make sure it's very clear.
Yeah, I think that's great advice, and maybe to be continued with an estate planner advisor with you. Well, let's talk about, this is also what I see occasionally. There are cases where one person in particular in the relationship handles all the finances. What would be helpful to educate some people about what to think about if someone's really the main person who's taking care of those finances?
Yeah, so I think this is kind of true even if there's not a divorce on the horizon, or everything is butterflies and rainbows in your marriage. I think we have this happen so frequently that it warrants definite conversation, where one individual is not involved in the finances, has no idea what's going on, uses the credit card, and there's no more conversation about their spending or income or anything like that. And that can really present some pretty significant issues in a divorce case, and it can create a lot of distrust and anxiety for individuals who then are facing a divorce, because you not only don't know where anything is coming from, you don't know what you guys owe, and you don't know what you spend. I mean, the ignorance that you feel then in the event of a divorce can be really, really, really overwhelming. And so because I've experienced that, watching that firsthand with clients, I think it's really important for individuals, and honestly women specifically, because I see this more with women than men, even if you're not the one intimately elbows deep in the finances, to make sure you have a high level understanding of where the money's coming from, how much money you guys are using, how much money you're spending. I mean, that's as simple as to the extent you get bank statements or credit card statements mailed to your house, look at them, just look them over. If you're not getting those, I mean, it's not saying, go to home and immediately demand to see all of the financial information, but just having an awareness of kind of what your assets are, I think can be really empowering for individuals. Another thing I recommend is, tax returns. I know a lot of people kind of just say, fine, I have no idea what this is, and I'll just, sure, file it. But they're a treasure trove of really helpful financial information. I mean, the first page shows you what you're earning as a married couple. So the first page, at least look at that and get a sense of what your income is. If you dig deeper, there's a Schedule E that should list some of your real estate, your rental income. If you have additional real estate, vacation properties, it should list, any interest you have in business, either you or your significant other. And so you can use that as a guide to just kind of like inform you on a much, broader level, but just I think having some knowledge is very helpful.
Yeah. And it's not just in divorces. It's also married couples that I know firsthand within a family member that one really knew about all the finances and took care of everything. And then health issues start happening and the other party doesn't know about. There's no will, there's
death, right.
or coming up for prior to death.
Yeah.
Of having all that in order, it is so important, whether it's for divorce or death. You just need to talk about it. I know it's uncomfortable. You don't want to go through probate. Communication is so key to prior to divorce or death.
It's true. And I mean, I would say there's always the caveat too, where we see where there's situations in a marriage where financial abuse is happening. And in those instances, trying to start asking for the financial information could really trigger a lot of conflict. And so obviously exercise your own discretion about what makes sense in your relationship. But I think, to the extent that you're able and feel comfortable having those conversations, it's so much better to at least have knowledge and ask than it is to allow inertia to kind of just carry you along and be blissfully unaware. So.
Yeah. In the event of a divorce, alimony, maybe talk a little bit about that aspect.
Yeah, so Colorado recognizes we have we call it maintenance or spousal support. Some states call it alimony, and it's intended to really help one spouse kind of get off of the ground running in the event of a divorce and get them back on their feet. So it's different from child support, and it's just intended to help that spouse meet their needs, reasonable needs, for a duration of time to get back kind of to the workforce and get back on their feet. So in Colorado, a court will look, it's not just as simple as saying, I get alimony because I'm getting divorced. A court will really look to the age of the parties, whether or not the individuals are able to work. Even if you haven't worked for a long time, I have clients all the time say, well, I'm a stay-at-home mom. I haven't worked in 10 years. And, I have to rip that Band-Aid off fast and say, well, you're probably gonna have to work again, because if you have the ability to work, a court might impute to you income that you would be earning if you were working anyway. So courts will look at that. They'll look at what other assets you're receiving as part of the divorce settlement. So if you're receiving assets that, for example, like stocks, and they are able to spin off some interest to you, that income from the interest will be considered in a maintenance request. So it's really, again, a very fact-specific determination about maintenance and alimony, but I would say I think a lot of individuals expect it outright, and they expect it to be a ton of money on a monthly basis that they might not necessarily be a realistic amount of money in light of kind of what your abilities are to go out and get your own job and start working again. And the other part of it is that it's not lifetime. It's not for the rest of your life.
Right.
So, there are instances where a lifetime award does make sense. Typically, those instances are when you're in your 60s and you're not really employable at that point in time. You haven't worked for 40 years and now it's time to go get, you can't go get a job. So there are circumstances where lifetime maintenance awards happen. But I think it's very empowering to walk into a divorce thinking I know I'm going to have to go get a job here. And, I'm not going to be taken care of here for the rest of my life as I would otherwise expect.
Right. So curious, are there any circumstances why someone would not have a prenup?
Yeah, absolutely. So I think that there are a lot of situations where people don't need prenups. For example, if it's your first marriage, you're in your 20s, and you both have nothing, you don't need a prenup. If you're okay with both of you kind of as a team growing your marital estate together, I don't see a need for a prenup. Obviously, if that changes and you then go and buy a dental practice, for example, while you're married, then maybe you would want to have a conversation about having a marital agreement done then. But I don't think that if you're, first time marriage, no significant assets, and you're good coming to the marriage and building together, I don't think you need a prenup in that situation.
And as you mentioned prior, you can always do a post-nup.
Yep.
So very helpful.
Yeah.
Now, to wrap it up, we need to let people know how they can contact you.
Yeah, so if you're, contemplating a divorce, or if you're an advisor, a real estate professional, estate planner who's just looking to build your network, feel free to reach out on LinkedIn. My last name is Chrobak, Chrobak, and I would love to connect.
That is great. Well, thank you again for coming and sharing all your knowledge and great information. I know I learned some things today that I didn't know, especially given the common law marriage that sometimes comes up in conversations.
Yeah.
So thank you so much.
You're welcome.
Appreciate it.
You're welcome.
Thank you all.